What's going on, guys? It is the Bad Wolf. All right. Now remember, every month I put out videos, at least 7, 8, 9, 10 to 14 videos. If you're not seeing them, it's because you either haven't subscribed to the bell, the notifications, or I'm being shadow banned. And if you want that information, hit the bell, like, and subscribe, and to be notified of when I do these videos or go live. Welcome to the tribe. And as always, if that doesn't work, always go to my main YouTube website, YouTube page, whatever you want to call it, and update yourself because they will not show you all of my videos just because I put them out. But the more you go to my channel, the more you go to my page, all that good jazz, the more you will see. So, plus, don't forget to hit the thumbs up because if you just watch the video and you don't thumb up it, thumb, you know what I mean. Put your thumb, never mind. But if you don't thumb the video, that sounds dirty too. Or like the video, then what happens is you just watch it and it doesn't make the high caliber to tell the algorithm that you want to see more of my videos, especially the new ones. All right, but nonetheless, let's get started. As always, guys, I'm the Bad Wolf, your host of hosts, international divine entity being the Wolf Man himself, Mr. Bad. All right, with that being said, don't forget, guys, the seminars have started production. We have not officially launched them, so it is a soft launch. You can see the information. Some of the videos are up, not all of them are done yet. We've had to correct some things, so some people have already started buying them, which is good, but we have not finalized the video. So if you do get one now, just know that this is the most up-to-date information as far as right now, but I may change it before we officially launch in case something new pops up or whatever else. Some things are still hot and running right now. All right, but we have received notifications from the various people and groups in the private that we are receiving high levels of success. So we're going to keep it rolling. Remember, individual results may vary. Everything here is considered education, entertainment purposes only. Do your own research so that you can stand on your own square, as they say. But I digress. Oh, wait, nope, I regress. If you see anybody using any of my information inappropriately or whatever, report the video for defamation of character, slander, and whatever else. As always, shout out to all the people out there who are my current students, former students, holding it down, doing it right, helping people, getting successes. So thank you for that. So another shot goes out to Eternal Zion. Some more people came my way. So thank you for sending people my way. Appreciate you. So support her as well. And to anybody else who supported me and continues to support me, even if it's just in name or recommendation, thank you guys. So with that being said, let's take a look at this. So what is a writ of Coram Nobis? All right, this is Latin. All right. So let's take a look and listen to what this is.
A writ of coram nobis is a writ of error issued by the court to correct errors of law in its own judgment. It is a common law tradition that allows the court to correct its judgment and administer justice should facts that would have changed the judgment but were outside the record and unknown to the court at the time of judgment surface. Despite its relation to newly discovered facts, the writ is intended for issues of law rather than issues of fact. The newly surfaced facts cast shadow on previously decided legal issues. See People v. Kim, 45 calories, 4th 1078, 2009. Specifically, the writ of coram nobis is intended to correct a final judgment by the same court in which it was rendered by redressing a fundamental error in law, such as a deprivation of the right to counsel in violation of the Sixth Amendment. In most states, the bar is relatively high for a writ of coram nobis. For example, in California, three requirements must be met before a writ of Coram Nobis can be issued. First, the petitioner must show that the new evidence was not presented to the court on the merits, that the evidence would have prevented the rendition of the judgment, and that it was not due to their fault or negligence. Second, the petitioner must show that the new evidence does not go to the merits of the issues tried. Issues of fact are precluded once adjudicated, even if incorrect. Finally, the petitioner must show that the new evidence was not known to them and that they could not, in the exercise of due diligence, have discovered the evidence at any time substantially earlier than the time of motion for the writ. See.
Okay, so this will work for many people, but your particular state, because we know that they're you know, buttholes, have things in place that say, well, these are our uh merits if you're going to try to use this particular writ. All right, so some states and federal court, they may have key requirements in order for you to use this. But while I have your attention, let's see here. It says writ of Coram Vobis. So let's see what that one has to say. Okay, let's take a look and to listen.
A writ of Coram Vobis is a directive from an appellate court to a lower court to review its decision in a case due to the presence of a fact which existed during consideration of the initial case, but was missing from the record due to some fraud, duress, or other excusable error. There must not have been negligence on the part of the party now seeking the writ. Functionally, a writ of Coram Vobis is the same as a writ of Coram Nobis, except the writ of Coram Nobis is issued by the trial court.
Okay. So once again, this is something that you might be able to do, which is to direct the appellate courts or the appeal courts to the lower court to review its decision in a case due to the presence of a fact which existed during the consideration of the initial case, but was missing from the record. Okay. So the court, you go to the appeals court and you tell them, hey, look, like, and this court, this is something that one of my students is working on right now because the court purposefully tampered with the evidence. They removed the audio from it. That is a violation. I object, Your Honor. The court or somebody has tampered with the evidence and the audio is missing. But what they also then did is pulled this person to the back and said, well, we're going to give you the video, but not the audio. But they also didn't put that on the record, so they did it privately. This was shady work. This was dirty work because that particular person didn't know that that is unexcusable. They didn't know what to do in that moment. So they went with it and tried to do their best. But the judge told them in the private chambers, you can't talk about this. Well, you can't tell me that you're going to suppress my evidence. Then tell me in private chambers that we're going to hold you in contempt if you talk about what was going on. These are due process violations and tampering with evidence. It's treasonous. You're trying to make sure I don't get my rights. But this person also beforehand did not challenge jurisdiction and did not invoke certain rights. So it's a mess. It's messy work at this point in time, but still yet, that's why now they're going to the appellate court to appeal what the lower court did. So now instead of one magistrate looking at it and saying some BS, you've got three judges who are going to look at it and see if there were some violations, and there were, done by the lower court to then make them overturn it or change the outcome. All right. So That's it, guys. Not a terribly long video, but just something interesting that may work for certain people out there. So if this applies to you guys, here's a little bit of some gem drop. Use it. All right. I'll talk to you guys later and stay out of trouble. Do not be a belligerent or combatant. Peace, blessings, light, love, live long and prosper.